the basics of intellectual property and technology transfer. Today we will be discussing how an innovative idea stemming from your research can be translated into a business venture. It is important that you, as a researcher, are cognizant of some key steps that you should be taking as soon as you formulate your idea. In order to do so, we will walk you through some of the basics of intellectual property and how the Penn State Office of Technology Management will assist and facilitate the commercialization of your research. Intellectual property. There are four categories of intellectual property: patents, trademarks, copyrights, and trade secrets. Our main focus will be on patents, however we will briefly touch on the other categories. Trademarks. What is a trademark? A trademark is a word, symbol, or phrase used to identify a particular manufacturer or seller's products and distinguish them from the products of another. Although federal registration of a mark is not mandatory, it has several advantages, including notice to the public of the registrant's claim of ownership of the mark, legal presumption of ownership nationwide, and exclusive right to use the mark on or in connection with the goods or services listed in the registration. Trademark rights must be maintained through actual lawful use of the trademark. These rights will cease if a mark is not actively used for a period of time, normally 5 years in most jurisdictions. Some examples that are shown in the slide are from well-known companies. One can immediately associate the products of each of these companies to the mark. Copyrights. What is a copyright? A copyright is the exclusive right to make copies, license, and otherwise exploit a literary, musical, or artistic work, whether printed, audio, video, etc. Works granted such right by law on or after January 1st, 1978 are protected for the lifetime of the author or creator and for a period of 50 years after his or her death. A work must be original and fixed in a tangible medium. Several exclusive rights typically attach to the holder of a copyright, such as to produce copies or reproductions of the work and to sell those copies, including typically electronic copies, to import or export the work, to create derivative works, that is, works that adapt the original work, to perform or display the work publicly, to sell or assign these rights to others, to transmit or display by radio or video. What are patents? As defined in the United States, a patent is a grant of a time-limited right of 20 years to exclude others from making, using, selling, or offering to sell the invention in the United States, importing the invention into the United States, and inducing others to engage in the above activities. This exclusion also applies to selling or offering to sell a component of the invention, if the component is a material part of the invention, made for a use that infringes the patent, and is not suitable for substantial non-infringing use. A simple definition of the term infringes is the manufacture and or use of an invention or improvement for which someone else owns a patent issued by the government without obtaining permission of the owner of the patent by contract, license, or waiver. What rights are conferred to an inventor? It must be understood that a patent is a contract between the inventor and the government. The inventor receives a time-limited right to exclude others from making, using, selling, or offering to sell the product. In exchange for this privilege, the inventor must provide a complete disclosure of his invention to the public. The government's policy is to balance two competing goals: economic incentive to innovate versus public disclosure for common good. A patent is personal property. A patent's right to exclude can be sold, assigned, leased, licensed, pledged, for example, as security for a loan. So why do we patent? Although most research is funded by the US government, for example NIH grants, The US government allows the universities to have ownership rights. This is one of the provisions known as the Bayh-Dole Act of 1980. In exchange, the universities are expected to generate intellectual property and that these discoveries are impacting the general public. Patenting is also important in today's world for many other reasons. For example, in order to get from the bench top to the real world, industry partner collaboration is essential. Companies are for-profit entities and will require technology be protected before they consider any sort of collaborative relationship, whether providing funds for basic research or the formation of a startup company. Once I have an idea, what must I do? Most important rule, write it down. Where? When? How? Who? Why? Although the US has moved from a first to invent to a first to file patenting system in line with the rest of the world, it still is important to write down your ideas. This not only creates a trail in case of litigation contesting your patent, but also serves to determine who may be inventor on a patent. Write down your ideas in permanently bound notebook, daily, in your own words, legibly, attach supporting data. Inventorship. Many researchers feel it makes good politics to include one or more other people on the patent application, for example, head of the laboratory, collaborators, etc. This must be avoided. An inventor is defined by law. Adding others knowingly who are not inventors constitutes fraudulent behavior. Who is an inventor? An inventor is a person who has contributed to the conception of a claimed invention. Thus, for example, if a product or method or device C requires A and B, and A was thought of by researcher 1 and B was thought of by researcher 2 during a laboratory meeting, both researchers would be inventors. The Office of Technology Management can assist in identifying who should be included as an inventor. In more complex cases, OTM would request the input of a patent attorney. Who is not an inventor? An inventor is not every co-author of a publication, someone who derived his/her invention from someone else, a person conducting any experiment following your instructions, for example, a lab technician, any work conducted under your guidance without the intellectual input of that person. I have followed your advice and I'm diligent in my documentation. What else should I be doing? Your responsibility. As a graduate student, postdoc, or employee of Penn State, we all signed, or soon will be signing, the University IP Agreement form, which outlines what our responsibility as a researcher includes, such as to assign all rights to discoveries and inventions to the university, to submit invention disclosures promptly to the university, to do whatever is required to help the university, at their expense, to protect the intellectual property, to maintain laboratory documentation and submit documentation to the university. The Office of Technology Management, OTM, is there to help you. It is imperative to involve OTM in every step of the process to minimize mistakes which could prove to be costly at a later stage. Discuss your ideas with OTM. Talk to OTM before you make any public disclosure. Remember, OTM is responsible for managing, protecting, and licensing the intellectual property of the faculty, postdocs, graduate students, and staff at all Penn State locations. If you think you have a novel idea, go to the OTM website and download or complete a hard copy of an invention disclosure form. Take the time to document the invention, as future value is difficult to determine. Be clear and understandable. This is critical for OTM to understand the invention and determine whether this invention has potential value. Accuracy is always important, as there is a lot of time and money spent both in the initial evaluation of the invention and the filing of a patent application. Completeness is also important. You are the one most familiar with your idea. Write the story behind the idea, what the idea is, and convey all the information you have to the reader who will evaluate your invention. Be candid. If there is anything, positive or negative, about your invention, make sure this is brought to the evaluator's attention. A good invention disclosure does not leave the reader guessing as to what may or may not be the invention. This slide provides details of required information on an information disclosure form. Listing previous ways of addressing a problem is important, as this provides the evaluator with a landscape of the current state of the technology. Remember, you are the expert in the field. Describing new alternatives is a way to show the evaluator where your invention stands out and how your invention stands out over what is already known. This is where the details must be precise and complete to help the evaluator understand and evaluate your technology. As we have discussed before, the value of a patent resides in the commercialization of the invention and its benefit to society. Describing the potential commercial aspects of the invention is critical to the information disclosure form for the evaluator to determine whether the invention has any commercial merit. This description also helps you, the inventor, realize the potential of your idea, which you may not have previously thought of. Licensing of the invention is one way of generating funds. Identifying potential companies or investors who may have an interest in your invention is helpful to OTM as a starting point to license the invention. A good practice to implement in your laboratory is the idea of collecting inventions. A good way to start is to make intellectual property review an element of each research project. One way is to envision your idea as a product on the market. Can it be used as a diagnostic kit, a device, a method of production, a therapeutic agent? The information disclosure form is very helpful in this context, as it will provide you with guidelines for evaluating your idea. It is also recommended you talk to OTM. They will assist you in evaluating your idea as to whether it has any commercial value. Sow the seeds for future entrepreneurs. Encourage those in your laboratory to think of the commercial aspects of their projects. So I've become adept on identifying the commercial aspects of my ideas. How do I know they are even patentable? Again, another good reason to contact OTM. The mission of the Office of Technology Management is to assist you in taking your idea and realizing its potential. What is patentable? Broadly speaking, a good guideline is a quote from the U.S. Supreme Court: "Everything under the sun made by man." However, under law, the invention must also meet certain criteria. Is it new? Is it useful? Is it non-obvious? Remember, what may seem obvious to you may not be obvious to your peers. OTM is critical in the process to make the evaluation of whether your invention is patentable. However, you as the inventor need to work with OTM to assist OTM in understanding your ideas. There are, however, some absolute barriers to patentability. One cannot patent laws of nature, natural phenomena, and abstract ideas. The applications, though, may be patentable. For example, Einstein's theory of relativity cannot be patented. It is a law of nature, but its application may be patentable. Other non-patentable items are mental processes, process of human thinking, and systems which depend on human intelligence alone for their operation. As a guideline, some potential inventions to look for when evaluating your research projects. Processes. Is your idea a method of producing something? Is it a new method of treating a patient? A method of rapidly screening large amounts of samples for a specific molecule? Machines. Is it a new device? Compositions of matter. Is it a new pharmaceutical agent? A new antibody? Manufactures. This is a catch-all to encompass whatever is made by man and not already found in nature. New uses for old things. For example, use of aspirin for treatment of heart disease, ornamental designs for articles of manufacture. The key is ornamental design. For example, the classic Coca-Cola bottle. Improvements of any of the above. As discussed earlier, patentable subject matter must meet certain legal standards. Is the invention new? The legal term used is novel. An invention is considered new or novel if it does not form part of the state of the art. What is the state of the art? The state of the art comprises everything that is known or used in public in any way, anywhere in the world, before the date of filing of the patent application. Can you as an inventor destroy your chances of obtaining a patent? The answer is yes. How? By publicly disclosing your invention. What may seem innocuous may actually constitute disclosure. For example, did you submit an abstract for a conference? Did you send a colleague of yours material from your invention? For example, your antibody, your novel culture medium, your plant clipping, your vector. Did you place any information of your lab meetings online? Did you update your lab webpage? Did you blog, tweet, or email aspects of your invention to third parties? Was your grant published online? All of this constitutes public disclosure. Make sure you contact OTM before doing anything that you may suspect constitutes public disclosure. Other examples of public disclosure: public use of the invention, sale or offer for sale of the invention, submission of an abstract or article for publication, giving a talk at a meeting or conference, displaying or promoting an invention at a trade show. In the United States only, an inventor may delay filing a patent application up to 1 year from the date of any of the public disclosure acts that forfeit rights. Foreign patent rights, though, will not be saved. The next legal hurdle to overcome with respect to whether an invention is patentable is the utility standard. It must be useful, and this is judged by the person who is skilled in the art, for example, your peers. So we'll take an example that you have invented a matrix that can transport a therapeutic agent across the blood-brain barrier. Then a person who is in the same field as you can appreciate why that matrix is useful. Utility must also be specific, substantial, and credible. Using the matrix example, the matrix has a specific use, that is, to transport therapeutic agents across the blood-brain barrier. It has a substantial use, can be used in a variety of treatment options, for example, time delivery, brain cancer, and it is credible. The invention functions for the purpose it was made. The next standard to overcome with respect to patentability is whether the invention is obvious. Again, the standard is judged based on the person of ordinary skill in the art, i.e. a peer in the same or similar field. The question is whether your invention would be obvious to them, not to you. In order to judge whether an invention is non-obvious, the Patent Office will look at several criteria. The level of skill in the art. Is it pioneering, with few possessing the level of knowledge? Content of prior art. This includes anything that is known and publicly available. What are the differences between the public knowledge and your invention? Lastly, are the real-world factors. Can you demonstrate a long-felt need in the market and any indicia of commercial success? Types of patent applications. Provisional. This patent application is valid for 1 year, after which it expires. A utility application must be filed on or before the 1-year expiration date. Utility. This is the patent application which, if granted, becomes the patent. The life of a patent is 20 years from the day of filing. Design. This consists of the visual ornamental characteristics embodied in or applied to an article of manufacture. Since a design is manifested in appearance, the subject matter of a design patent application may relate to the configuration or shape of an article, to the surface ornamentation applied to the article, or to the combination of configuration and surface ornamentation. A design for surface ornamentation is inseparable from the article to which it is applied and cannot exist alone. It must be a definite pattern of surface ornamentation applied to an article of manufacture. Utility versus design. In general terms, a utility patent protects the way an article is used and works, while a design patent protects the way an article looks. Both design and utility patents may be obtained on an article if invention resides both in its utility and ornamental appearance. The term of a design patent is 14 years from the date of grant. Advantages of a provisional patent application. A provisional patent application does not start the 20-year patent term. Provisional patent application can defer examination for 1 year. By starting with a provisional patent application rather than a full patent application, you gain more time to gather information, run more tests, determine the broad range of potential uses, determine if industry is interested in the technology. The Patent Cooperation Treaty, PCT. This application can be filed instead of or with a utility patent application, on or before the 1-year expiration date of the provisional patent application. The advantages of filing a PCT are numerous. Most efficient approach when filing in multiple countries, and over 100 countries are members. Permits countries to be designated for national filings, which can be delayed for up to 30 months. Permits buying time until commercial status of invention and/or status of U.S. application is resolved. If a U.S. utility patent application is not filed at the same time as the PCT, the utility application must be filed by the 30-month dating from the time of filing of the provisional patent application. This looks like too much work. I'm too busy, I have to publish, I have to write grants, I have to lecture. Everyone wants a piece of me. Uses for patents. Income. It can be an excellent source of renewable funding. Penn State is generous with their revenue splits. 40% back to the inventors, 40% back to the Penn State Research Foundation, and 20% to the administrative unit of the primary inventor. They are also useful in negotiations to provide litigation and licensing bargaining chips. Other uses for patents. A patent is property and can be bought and sold. Patents add to the value of an institution or company. Owner of a patent can license the patent to others to make, use, or sell a patented invention in return for a royalty. Patents can be used as a trade to give a competitor a license in exchange for the competitor's license, known as cross-license. Enforce. Go after infringers. Force them to license or stop manufacturing. If litigation is required, this can be very expensive and time-consuming. Good that PSRF is there to do this for us. Here are some other real-world examples of uses for patents. By no means is this an exhaustive list. I have great ideas. All the time. Consider the expense of filing a patent application. This chart gives a rough estimate of each stage of patent applications filed for both the US and foreign rights. Costs escalate from $5,000 to $165,000. Therefore, you can see why it is imperative that your invention has commercial potential associated with it, and why it is important for you to engage with OTM from the very beginning. With respect to foreign filing decisions, it is important to consider markets and competitors. This is more a business decision. For example, which countries would your invention have a market? Is that market flooded with competitors' products? And would it be worth the expense to enter that market? Keys to success with technology transfer. Do's and don'ts. Do. Fill out information disclosure forms completely. Identify publication presentation dates. Seek meeting with OTM. Demonstrate knowledge of prior art and your improvement to it. Evidence of fundability. Build relationships with companies of interest. Don't send just a manuscript. Give short notice of publication presentations. Withhold information about funding or material sources. Assume OTM will file patent applications and find a licensee without your input and involvement. Enter adversarial relationships with OTM. And lastly, drive unreasonable license terms. In review, to graphically depict the patent process, you must first contact OTM and file an information disclosure form. At this time, OTM will conduct a bid for attorneys to conduct a patentability search and file the patent application. There will be a search for prior art. If the search is clear, the attorney will work with the inventors to draft the provisional patent application. This will take roughly 3 months' time. Once the provisional patent application is filed, you are free to talk publicly, submit papers, write grants. During the 1 year that the provisional patent application is pending, OTM will be exploring market potential and interest, while you will continue your research related to this invention. At the end of 1 year, a decision will be made whether to file utility PCT application. Frequently asked questions. What are my rights as an inventor on a patent? Each inventor is an owner on a patent. However, as an employee of the university, you are obligated to assign your interests to the university if the invention was made during your employment and using university resources. By assigning your rights to the university, ownership is now vested in the university, which can make the decisions regarding the patent or patent application during prosecution as to whether to sell, license, or use in any way. Bear in mind that the university has policies in place which inure to the inventor's benefit. What is the purpose of claims in a patent? Claims define the invention and are what are legally enforceable. They are extremely important. When drafting the patent application, the claims are usually written broadly, but will likely be restricted by the Patent Office during prosecution. It is very important to be very clear with both OTM as well as your assigned attorney when describing your invention, so that the description of your invention and the property that is being claimed is accurate and reasonably broad. If 2 or more persons work together to make an invention, who will be the inventor? If each had a share in the ideas forming the invention as defined in the claims, even if only as to one claim, they are joint inventors, and a patent will be issued to them jointly on the basis of a proper patent application. If, on the other hand, one of these persons has provided all of the ideas of the invention, and the other has only followed instructions in making it, the person who contributed the ideas is the sole inventor, and the patent application and patent shall be in his/her name alone. What does it mean to have a patent application filed? Once the application is filed, the invention is described as patent pending. The owner of the patent application does not have any enforceable rights at this time, only the right to pursue the patent application and preserve the right to protect the invention and claims as the first inventor on the date the application was filed. What is the restriction requirement? When filing an application, fees have to be paid to the Patent Office. One of the fees that are paid is the search fee. The Patent Office will review the claims when an application is filed, and they will separate the claims into groups depending on the search parameters. If the Patent Office deems there is more than one invention, they will issue a restriction requirement requesting the inventor to choose one of the inventions for the Patent Office to search and examine the application. What happens to the other claims? The other claims remain unexamined and are deemed withdrawn. This does not mean any loss of claims. Simply put, the Patent Office has put them aside and will not examine them. In order to have the other claims examined, a divisional application must be filed during the pendency of a patent application. What is an office action? An office action is a letter from a patent office in which a patent examiner makes an official communication to the patent applicant about the status of the patent application. Most office actions are written by a patent examiner after examining a patent application for the purpose of expressing the examiner's opinion regarding whether some or all of the claims in the patent application are allowable, i.e. patentable. If the office action indicates that some or all of the claims are not allowable, then the applicant has an opportunity to respond to the office action, such as by arguing that the examiner is incorrect and/or by amending the claims in an attempt to overcome the examiner's rejections. What goes into response to an office action? The examiner will cite one or more rejections based on publications identified during the patent search, and will cite these against the patent application for lack of novelty or obviousness. A response to the office action involves amending the claims and/or arguing against the examiner's position. There are strict rules regarding how to respond to the office action, particularly when making amendments, which is why a patent practitioner should be consulted. The examiner can also be contacted at this time to conduct an interview to discuss the likelihood that any amendment or arguments will be successful. What is a final office action? A final office action is issued when the examiner did not find the amendments and/or arguments persuasive and is maintaining his or her rejections or has found new grounds for rejecting the claims. Does that mean I cannot get a patent? No, final office action does not mean the end of the process. Claims can be further amended, and the examiner continue to examine the application by the filing of a request for continued examination, RCE, which means extra fees. Other alternatives include filing a continuation or a continuation in part application, or filing an appeal to the Board of Patent Appeals and Interferences challenging the examiner's rejections. Is my United States patent valid internationally? The United States patent protects your invention in the United States only.